Uh,
Please.
Mr. Harari, counsel for the appellant, pays for adjourning the matter for 3 weeks. So this being a 2018 matter, long adjournment cannot be given. So therefore, lists the matter after a week.
Madam President.
Yes.
Madam, I beg to mention for listing of criminal appeal against conviction, madam, either on Friday or Monday, madam.
Make it Monday, give it to the court master. Therefore, listing, please give it to the court master.
So sir, I beg to mention item number 15 of daily list.
Items
15, 1-5 lordship.
1-5.
So I'm praying if your lordship may kindly adjourn the matter today and fix it on next week lordship.
No, this is orders matter. You have seen the office note, why it has come?
This note, lordship, LCR has been called for, it has not been received, my lord. And in the IA, the state have already.
No, what is this office note?
Office note, lordship.
No, don't make an adjournment when there are office notes. You should go through the file. We'll give you a notice why the appeal should not be dismissed for not taking steps.
No, lordship, notice was not issued in this matter, lordship. In fact, there are two respondent number one is the state and two is the informant. And the learned PP has accepted notice on behalf of both the respondents, lordship.
That is okay. Your English is good, but the facts are wrong. Don't waste morning time. Look at the file. Look at the first order. What does it say? Issue notice.
Lordship, notice have been accepted by.
Go to the office note. What does it say? Steps not taken. So we are giving you a notice why it should not, the appeal should not be dismissed for not taking steps. Don't waste the time of the court. You should have looked at the file before making a submission.
We'll take steps today itself, lord.
Office note indicates that steps for issuance of notice on the respondent number 2 has not been taken. So accordingly, the court is inclined to put the appellant to notice as to why the appeal should not be dismissed for non-prosecution for not taking steps. Full stop. However, liberty is given to the appellant to take steps within 2 days, during which the matter would be listed before the court for appropriate orders. Full stop. If steps are taken within 2 days, list after list one, give a date after 6 weeks. List on so and so for service depot. In addition to usual steps, steps shall also be taken by Registrar Post Vidhi. In addition, the appellant should take steps by usual process to be served through the jurisdiction magistrate. List on so and so for service report. It's okay because we are having criminal matters. Oh, actually. Yeah. Yes.
May I appear? I would like to mention the item number 24 of today's list. I will
20.
allow some time to go through it, Lord. Item 24.
Okay, you want an adjournment today? Okay. List after a week is paid for by Mr. A. Ahmed, counsel for the appellate.
Public.
May I please, madam, my appeal is directed to be listed after 1 week, madam. The 1 week has elapsed now, madam. May I pay for listing on Friday?
Friday means tomorrow.
No, madam, day after tomorrow.
Day after tomorrow. Okay.
Okay.
Day after tomorrow then. Item number?
Today, madam, I am list for list.
Oh, then give it to the court master. Let him take the call.
Fine.
Yeah.
I'm praying for Friday, madam.
No, it's okay. I'm not saying anything. Let the court master take a call because I don't know the calendar.
Daily list item number 1 for Musa.
May it please, your Lordship. Lordship, this matter has been, this writ petition has been directed against the order dated 21 to 23 by which the OE was partially allowed. What happened, Lordship, in this case, the respondent was appointed as a clerk in the year 1988. And
No, but you see, the prayer is for recovery of money.
money.
That after, what you call this,
Lordship,
Masi Rafiq.
if your Lordship comes to the CCS pension rule, Lordship.
No, you see,
Rule
even after that,
71.
I'll tell you something, just a moment.
Because it was allowed on the ground of equity. That has been reflected in the
But
order.
there is a recent judgment after Rafiq Masik also, there is a judgment of 2022 by the Supreme Court
Lordship.
reiterating the same thing. I'll
So
just
whether
give you
this
that.
CCS aspect has been dealt with, Lordship.
Everything has been dealt with.
Lordship,
Thomas Daniel,
Lordship, the citation.
this is AR 2022 SC 2153.
In our case, Lordship, thus the difficulty is that the 24% has been wrongly given. If one, we can waive, the other 23 will come.
No, I understand, but you see, in this judgment, the Rafiq Masih was reiterated, and the specific direction here is, it is not possible to postulate the same thing which Rafiq Masih said. Postulate all situation of hardship. The as a ready reference, summarize the following few situations where recoveries by employers would be impermissible in law. One, recovery from employees belonging to class 3 and class 4 service or group C and group D service. Recovery from the retired employees or employees who are due to retire within a year of the order of recovery. Recovery from the employees where the excess payment has been made for a period in excess of 5 years before the order recovery is issued. Recovery in cases where employee has wrongfully been required to discharge duties to a higher post. In any other case, the court arrives at a conclusion that the recovery if made from the employee would be iniquitous or harsh or arbitrary to such an extent it would far outweigh the equitable balance of the employee's right to recover. So here, it was almost similar facts where the respondent was given excess payment.
Lordship, in all respect, in all these cases, the element of equity and the hardship, that was the only considered, Lordship. There's a specific, Lordship, can you go through a CCS pension rule, rule 71, Lordship?
71. On Rafiq Masih line. This is Daniel. This is Abdul Nazir and Vikram Nath. University of Kerala. My brother remembers there is also a judgment by Honorable Chief Justice of India on the same matter, following which even my brother had the same opinion in one judicial
Normally,
pronouncement.
that is the view, Lordship, generally, Lordship. But I don't know whether the CCS, this 71 rule has been dealt with or not.
Which rule?
Rule 71 of the CCS rule. Because that is specific and very clear, Lordship,
Pension rules.
pension rule.
Section
Rule 71.
Rule 71.
Recovery and adjustment of government dues, Lordship. And government dues is also defined under Rule 3.
overpayment of pay and allowance. That is also included in the definitions also.
Whether the employees were put to notice or not,
Lordship,
whether notice, they were put to notice.
Lordship,
It is
for
with-
that regard, Lordship will kindly see the condition under which we fix the pay. It's come with a rider that any wrong or whatever miscalculation that can be corrected. On that aspect, Lordship, Supreme Court has dealt with. It is come with a condition that of course there is an undertaking he has to sign. I don't know whether undertaking was given or not, but when it's come with a condition, Lordship, that any wrong done that has to be written, Supreme Court has dealt with, then it has to be written, Lordship.
But then before you admit,
Lordship, you should not let them find that reply. It
No, no,
has to be dealt with,
no,
Lordship.
no, before we issue a notice,
Lordship.
you take instructions and file an affidavit whether the undertaking was there or not. Because if it is not there, we may not issue a notice then. Uh, Heard Mr. B. Chakravarti Lanet CGC appearing for the petitioners. Also heard Mr. A.H. M.R. Chaudhary, counsel for the respondent caveator. Next paragraph. Admittedly, the respondent is a Group C employee.
Group C.
And insofar as issue of recovery of overpayment made to the Group C category employees is well settled in the ratio laid down in the case of State of Punjab and others versus Rafiq Masih, MASIH, within bracket whitewasher, and others, 2015, 4 SCC 334, which is followed by another verdict of the Supreme Court of India in the case of Thomas Daniel D.A. NIEL versus State of Kerala, AR 2022, SC 2153. Full stop. Next para. In context of these said decisions, the learned CGC has submitted that in those cases,
In those cases, I'm relying on some.
no, it's okay. In those cases, perhaps the provision of section, Rule 71 of the Central Civil Services within bracket pension, bracket close rules, 1972 was not considered. Full stop. Next paragraph. The CGC is directed to obtain instructions as to whether the respondent had given any undertaking to refund the excess payment if any made in course of his service. First of all, on the said ground, the matter stands adjourned today so as to enable the learned CGC to obtain instructions. List again after.
Week.
Suggest a date, we'll fix it then.
Lordships, 17 or 21st, Lordship.
21st of August, 21/8/2023. In the motion column. The caveat right is present, caveat since discharge will be heard in the connected writ petition. Yes.
Obliged.
Item number 2 for admission.
This preliminary appeal, my lord, filed against the ex parte judgment, my lord, whereby, my lord, divorce petition by the, my lord, husband was allowed, my lord. Background of the case is that, my lord, when he filed, my lord, the divorce petition before the family court at Silchar, my lord. Then, my lord, having noticed, my lord, the humble petitioner, that his wife preferred, my lord, one transfer petition before this honorable court, my lord. Accordingly, my lord, this honorable court was pleased to, my lord, stay the further proceeding of the, my lord, case pending before the family court, my lord. Then, my lord, he also, my lord, engaged advocate, my lord, before this honorable court in the, my lord, transfer petition. I have stated, my lord, paragraph 8, page 7 of the memo of appeal, my lord. And engaged lawyer, my lord, on 29/2021, my lord. Nevertheless, my lord, he pursued simultaneously, my lord, this, my lord, divorce petition before the family court, which would be, my lord, visible at page 52 and 53, my lord. I beg to refer to dates, my lord. After engaging lawyer on 29/2022, and he pursued this matter before the family court, my lord, page 52 and 53. These two dates, my lord, 52, this is dated, my lord, 30,
52, 53.
53, my lord. This is dated, my lord, 52/30/10/2021, and my lord, 17/12/2021, my lord. Thus, my lord, he obtained this, my lord, ex parte judgment, my lord, page 54, my
No,
lord.
no, but somewhere I read that the transfer petition was allowed and the
Yes, my lord.
case was
but,
transferred.
On the day of, my lord, the final hearing of the transfer petition, my lord, learned counsel on behalf of the, my lord, the husband absent, my lord, and this honorable court, my lord, taking note of all these circumstances, my lord, transfer petition was allowed, one.
Where is the order of the High Court?
Yes, my lord, this is, my lord, the page, my lord, the 43, my lord.
Now, this is the order of
Final
this
order.
is- no, 25/1/22.
Yes, my lord, this is final order, my lord.
25/1/22. Now. It is transferred to family court Silchar.
From Silchar to Hailakandi, my lord.
To District Judge Hailakandi.
Yes, my lord.
Okay, then what is the next order of the trial court after 25/1/22?
Yes, my lord. Then, my lord, he this compliance with this order, my lord, the lordship kindly will look page, my lord, 61, my lord.
61.
61. Following this order, my lord, he transferred this case to Hailakandi, my lord.
Yes.
Already disposed of matter, transferred, my lord.
But then the court notice was issued.
61, my lord. Case record is put up today in view of order dated so and so passed by the Honorable Guwahati High Court in transfer petition number so and so communicated by memo number so and so. So and
So
so.
it's okay. After that, you see steps was issued and then come to page 64.
Yes, sir.
64, the defendant side appeared and filed a petition. Therefore, so notice is served.
Yes, my lord. So, my
Then-
lord, notice, sir, my lord, appearing both the party, my lord, but petitioner, my lord, before your lordship, she, my lord, assuming that my lord matter is yet not disposed of, but subsequently,
Oh,
some,
that assumption, you should have asked the district judge there. Somebody would have told you.
yes, my lord.
But if you see, you appeared by filing a wakalatnama.
Yes, my lord. Now, my lord,
So
case is
now-
not
now-
disposed of.
Hmm?
Now not disposed of, but in the proceeding before the family, my lord, district judge Hailakandi, it is found, my lord, everybody that, my lord, this case was already disposed of by the family court Silchar, my lord. So, my lord, all these exercises are meaningless, my lord. Perhaps, my lord, district judge also could not, my lord, understand that, my lord, this case was already disposed of.
Where is
Because,
that order of disposal?
my lord, disposal order, my lord, page 54, my lord. It is also, I have next year, my lord, 54, then relevant portion of page 56.
Yes. Where is the interim order of stay by the by this court?
My lord, this is, my lord, at page, my lord, 34, my lord.
34.
Yep.
Yes, what do you have to say?
Lordship. We are appearing for the husband, Lordship. Lordship, during that period, though we filed wakalatnama in the transfer petition, but we could not appear before this honorable court, Lordship, because due to some illness, I was also out of station. And so we also did not file any objection there. And anyways, Lordship, as this is, as challenge has been raised before in this case, Lordship, against an ex parte decree. So they could have filed a petition under Order 9, Rule 13 for setting aside ex parte decree before the trial court itself.
Is it fatal if order 9 rule 13 is not filed? Is it fatal
Order
for
9,
maintenance of the appeal, present appeal?
Lordship.
Non-filing of order 9 rule 13, will it non-suit the appellant in this appeal?
Lordship, in any ways, because they have, because any order of the trial court, family court can be challenged before the High Court, Lordship.
The motion is pending.
This,
This 12/7/2021. After this, what is the order of the trial court? You have given the continuous order sheet? No.
yes, all order I have given.
Where is that order? After 12/7/2021, where is the order of the trial court?
Oh, my lord, that court's order, my lord, the 12.
Because if that order after 12/7/2021 is page 49,
Yes,
then you did not bring the stay order to the notice of the trial court.
my lord, my lord, submission is that, my lord, then, my lord, some, my lord, COVID circumstances are also there, my lord. She submitted, my lord, lady, my lord, to the bench master, my lord. But it was, perhaps, my lord, it was not, my lord, brought to the court, my lord. Nevertheless, my lord, he himself, my lord, submitted wakalatnama and
In this April, my lord, earlier occasion, delay was condoned.
So it is coming for the first time, the appeal. Okay. Ms. P. Bora for the appellant. The appeal is admitted for hearing. Steps within 2 days for service of notice on respondent 2. By usual process and registered post both. Date for appearance, 4 weeks.
There is an I also.
Okay, that will be considered on receipt of the LCR.
Notice may be issued in.
No, we'll issue notice. It will be considered on receipt of the LCR.
Obliged.
Achha, just write presence of Mr. D. Das. Then the AVP.
For
Come up for the first time.
First time,
Mr.
case minute 14.
MU Mandal, counsel for the appellant. Okay, take steps within 2 days, service of notice on respondent 2. List after 4 weeks. We're calling for the records also. Call for the records. Aage. Yes. Item 5, come up for the first time.
Lordship.
Okay. Mr.
Ayu Chaudhary.
Ayu Chaudhary for the appellant. Mr. D. Das. Call for the records. Take steps within 2 days. Take steps within 2 days.
Lordship, another appeal file arising out of same judgment, Lordship, which is numbered as Lordship, criminal appeal number 25423, Lordship. That may
No,
be
at this stage, I'm not tagging together
Lordship.
because if service report is not complete in one, none of the cases come up on board.
Lordship.
You make an prayer when the service is complete.
Lordship.
Ah.
Obliged.
Otherwise, you will be the sufferer.
Lordship.
If in one case there is no service report, the other case also. So can't be taken up.
Lordship. Obliged.
for orders,
Yes, right is come for orders.
Lordship, on the last occasion, there was some clarification was sought for regarding issuance of taking up of steps. In this case. So,
Oh, acha. Yes,
steps upon the
yes,
informant.
yes. So you have to take first steps.
Lordship, yes, Lordship. Initially, my lord, when the matter was admitted, my lord, by the order dated 1/6/22, my lord, we informant was not made as a party in our appeal memo, my lord. So By the order dated 19/10/22, we were directed to imprint the respondent number 2 by hand. And thereupon, my lord, there was an order to take steps against the informant. That order was passed in IA criminal, my lord, 244 of 22, and 230 as well as in 239 of 22. So on the basis of that, we have taken steps, my lord,
No, but here also you'll have to take steps.
in appeal, ma'am. Because
Pass
by-
separate orders, huh? Pass separate orders. Mr. R. H. Chaudhary, counsel for the appellants, appellant is present. Appellants, yes. In view of office note dated 7/8/2023, the appellant is the learning counsel for the appellant is directed to take fresh steps for service of notice on respondent number 2 by registered post with AD as well as by usual process to be served through the jurisdictional magistrate. Next, the office note dated 7/8/2023, indicating that paperwork is under preparation. Next, list after 4 weeks awaiting service. This order will be there in
Item number 5.
next item also.
7.
In next item also. One, third item also. All 3 items, separate orders you are passing for step
I'm appearing in item number 6 and 7.
6 and 7. You are in 8. Okay, Mr. L.R. Mazumdar in item 8. 6 and 7. Okay, take steps.
Like.
Wait, please. Hello, this NCR has been received.
So we'll have to direct for preparation by paper book.
It's a not jail appeal matter, privately engaged.
No, that's okay, but still paper book has to be prepared.
Yes.
Mr. V. Bhagwan, counsel for the appellant is present. Office note dated 4/8/2023 indicates that steps for service of notice has not been taken. Accordingly, the appellant shall take steps. Counsel for the appellant shall take steps for service of notice on respondent number 2 by registered post with AD as well as by usual process. Steps within 2 days, huh? Next para. In the meanwhile, the registry shall prepare a paper book. Next para. List after 4 weeks awaiting service. Steps you'll have to take.
I'll take it.
Then
Please, your lordship. Lordship, we haven't received the paper book yet, so kindly short that may be given.
Paper book is ready, you have taken it,
No, we will collect it.
you will collect it, okay. But this is our- I think no has gone wrongly. It has to be. No, it is wrong. Uh, Miss
B. Hazarika on behalf
B. Hazarika, counsel for the appellant is present. But she submits that the paper book is ready and she will collect the same. Next para. In view of the ratio laid down in the case of Jagjit Singh and others versus Ashish Mishra, alias Monu and another, 2022 9 SCC 321, whereby full participatory right is given to the victim, letter notice be issued on respondent number 2, returnable in give fixed date, returnable on Wednesday. The appellant shall take steps within 2 days for service of notice on the respondent number 2 by registered post with AD as well as by usual process to be served through the jurisdiction of the magistrate. Awaiting service list on
11/9.
11/9/2023. There appears to be a typing error in the order.
Notice was not issued on earlier. Maybe notice was not issued, Lordship.
But that appears to be incorrect order. That no is, I think, erroneously typed. Jagjit Singh requires notice to be served.
Lordship, that
Gives participatory right. That,
Lordship, she may come later on also, Lordship, as per, but
that regarding notice, there is no mention in the judgment.
No. How she'll participate if she doesn't have notice? Today I hear and dispose it off. How will she participate then?
After that, our divisional judgment is there that in every POCSO case, that notice is required. So in that view.
Participate right means I have to inform her. Otherwise, what is the right of participation when I hear the matter, close this gate and then hear the matter?
our division bench High Court judgment 23/6/2023, after that order, Lordship. That is in criminal appeal J.
I know that it requires notice to be served.
Yes, Lordship.
So that's why,
Otherwise, or by an amicus curiae, Lordship.
no, amicus will come only when
If
she
doesn't
notice is
come.
served and she doesn't come.
Yes,
Then, okay.
obliged.
Eleven,
Give a notice to A Dhar. Notice to A Dhar advocate, amicus curiae in item 11. A Dhar, advocate. We'll wait for some time because amicus curiae is not there.
twelve,
My pleasure, Lordship. Lordship, I will already admitted, Lordship, LCR is received, Lordship. Look, we have filed on IA, Lordship, for bail, Lordship, in the IA, Lordship, service is completed, Lordship. And the respondent, state already filed their written objection, and the respondent had also appeared, Lordship, and filed their affidavit. In IA, they filed their affidavit, Lordship, and state side also filed their written objection, Lordship. Here in this case, Lordship, IA may be taken, Lordship.
But we don't find this to be a case where we can enlarge you on bail. We'll have to hear the matter.
I may be fix another date, Lordship, file.
Huh?
I may be fix another date, Lordship.
We'll fix the entire matter for hearing if the paper book is ready. Paper book is not yet ready.
Lordship, I may be fix, Lordship, there's a bail, Lordship, and
Bail, we are not inclined.
in deposition, all the deposition in English translate, Lordship, English person, Lordship. Maybe I may be taken.
No, I will take it up today also. There is no issue. But we don't find this to be a good case for releasing you on bail.
Lordship, there is a good case, there is a love affair between the victim and then the appellant.
No, but you see, this offense is complete.
Here in this case, Lordship, there is a the
The
learned
victim
court
at that point of time was 16 years old. The medical examination, she was found pregnant.
Yeah, in this case, there is a contradiction of his lordship. And the conviction only sole basis on the birth certificate, which is not duly proved by the issuing authority. Lordship.
No, it's not required. You see, birth certificate is a official document. It's not required that the issuing authority will come, because the issuing authority by itself doesn't prepare it. When a child is born, it is the family members who are reporting that birth to the concerned authority, and they are recording it. So it's an official document. We don't require the registrar to come in and depose, because the reason for not entertaining the to not grant bail is you see, as per the birth certificate, if it is considered, then she would not be 16 years, she would be 14 years.
Lordship.
So
But,
she would be still a minor.
but apart from that, lordship, the trial court failed to appreciate the medical opinion report, lordship, which is kindly turn page, lordship, page 11, lordship. This is a medical opinion.
Just
the
now.
Assistant Professor Forensics Department, Medical Science, lordship. In my I have annex, lordship. But in the medical opinion, lordship, expert, in a medical opinions and paragraph 4, lordship, and here is her age is above 17 years and below 19 years, above 17 years in a medical opinion report, lordship.
Medical report, opinion report, you see, will not override the documentary evidence.
Okay.
Principle is, I think it is 61 of the Evidence Act says the evidence should be primary. The medical ossification test has a what do you call,
Suggestive only.
only suggestive, and it gives a window of two years plus minus.
Yes.
So if the documentary evidence is available, then you can't take the benefit of the medical opinion.
Apart from this, lordship, out of the love affairs and they married, thereafter the one child was born, lordship, and now victim also in the house of the appellant, lordship. The appellant side also appear they have no objection, lordship, regarding the bail, lordship. They file a affidavit, lordship. Petition appellant already behind the bar, lordship, 539 days, lordship. If you see the deposition, lordship, there is a contradiction of age also. In a paper, 14 years.
You see the deposition of the father.
Father.
It is in your cross that you have asked him a question, and he says that my doctor was not above 18 years.
16 to 17 years.
You see the PW1 cross.
In cross, he said that my daughter is above 16 to 17 years.
So therefore, she becomes a minor. Age of minority is there, and that has come in the cross examination.
But
Look at the
in-
cross of PW1.
But in a deposition of PW2, he clearly said that I'm voluntarily eloped with the appellant, lordship, and thereafter we married each other, and now she want to live with the appellant, lordship. I think this I want to rely on judgment of Honorable Supreme Court, lordship. From page 2, lordship, last para, lordship. Below, lordship, below. Dr. Joseph Aristotle as learned counsel appearing for the state opposed the grant of any relief to the applicant on the ground that the this was.
You see,
as-
this judgment which you have cited, here the Supreme Court interfered by, in view of the power under Article 142. You'll have to show us that the High Court in exercise of the appellate power under 374 would have a power to condone the offense and then allow the matrimonial conjugal life to proceed.
I am not for, I am only for bail lordship,
No,
honorable.
You see, principle will be same.
Equity the case.
No,
lordship. Now
principle would be same. You see, if the offense is complete, then we are bound by Satyendra Kumar until. And where it says that if the accused is arrested for a heinous crime and is awarded sentence, which is more than 10 years, then only after conclusion of half of the sentence, then the prayer of bail can be considered. We just can't brush that opinion of the Supreme Court aside and arrive at our own decision. But then Satyendra Kumar until will come to the fore.
now victim already married lordship. In the
No, this-
no one in the society will accept the wife as a wife in the society because she already married lordship and one child was born lordship. And other
No, I
side-
agree, but you see, my brother has
Can-
pointed out. This is something I.
This is not
uh,
precedent,
I-
lordship, as in the clear in the
Ah.
judgment, this is not precedent.
Yeah.
I'm just only for bail, lordship, not in this case, lordship, the Honorable Supreme Court acquittal the case. I'm only for just bail, lordship. That's why I'm placing lordship.
Mr. Das,
There is no 66, it's not coming, lordship. There is no force used by the.
no, it's not that. You see, there is a presumption of offense under 29. And therefore, what has happened that irrespective of the fact whether there was a love affair or they eloped, the question is that the offense is complete. Once the offense is complete, then I told you, we are bound by the ratio laid down in the Satyendra Kumar until where ABCD that has been prescribed, where you can't consider the prayer for bail without half of the sentence being undergone. And that's a larger bench decision of the Supreme Court. You just can't brush it aside. If we prepared, we'll take it up any other day. I don't want to discourage you. You also see that Satyendra Kumar until. It is just because they are living a conjugal life, you are saying, but giving an opportunity to improve your argument on bail.
Father
Okay.
also no, they can informing. lordship.
I know that, you see, but
Because they are
consensus-
happily living with their.
consensus between the appellant and the wife. That may not be the sole consideration for the court to examine the prayer for bail.
And this both are so young, lordship. At the time of incident, lordship, accused also 19 to 20 years, lordship, and victim also 16 to 17. Not exactly 18 years, but in between, lordship.
No, Mr. Islam, there are two things. Number one, we continue to hear on merit, or number two, you get an opportunity of improving your argument. What is the one you want to elect
So next,
next day?
He may file a petition before the government also under section 432. Under section 432.
They can appeal
appeal-
the cover. He's
before the
right.
government also.
That is a better idea. It
That
never
will be
offered to
better
me.
For him, for the present purpose, at least.
He's right. I think that you can explore. We are so engrossed in law that we don't even remember 432. Pardon from the government.
Well, my learned friend says, well, they are married.
No, I understand, but the question is a question of interpretation of law.
Yes.
Even if I want to, Satyendra Kumar until doesn't permit us to do so.
432 petition upon the government.
that can be.
Is this matter on when?
Immediate. Any date, Lordship, next week.
Next week, any date. List on. (16/8/2023) for consideration of the clearing the interlocutory application. Sorry, Mr. V. Islam for the petition, for the appellant, Mr. D. Das, additional VP for respondent number 1. P. Burakan for respondent number 2. This citation would help us because it is not to be cited as precedent. So better come with equipped with another judgment.
13,
Yes.
Here also I have filed one interlocutory application, juvenility lordship, and accordingly, the session judge was directed to submit a report after inquiry. Probably that report is here.
It has come.
It has come.
Yes.
17.5 now.
That's a good question.
No, it was okay.
It was a below was 17 years, 5 months, 13 days old. We'll give you a copy of this report. You have to make your submissions because as per the report of the district judge, the appellant on 23/6/2020 was 17 years, 5 months, 13 days old. So he was juvenile at that point of time. So you'll have to make your submissions on that.
Whether any witness was examined by the.
Yes, but headmaster was examined at court witness number 1. Other witnesses were examined. The
And cross-examined by.
headmaster brought the school attendance, school register of class 1 and 2. No, because this is an inquiry, post judgment inquiry. So it's not required to be what you call cross-examined by the APP.
No, I have earlier I have come across.
No, cross-examination is not done here. In this case, it was done, but it was made an inquiry.
That aspect is cleared by Honorable Apex Court in Ashwini Kumar Saxena judgment. That aspect is cleared by Honorable Apex Court in Ashwini Kumar Saxena judgment. That it is a inquiry regarding that inquiry, that part, how it has to be conducted.
We'll ask the section to give you the entire set.
No, why I am raising this concern? Earlier in code, before code number 1 in the old building, I have come across a situation. A Venture school headmaster has come with a birth certificate, which is forged, and subsequently his name has been entered in the register. He was not a student at that time. So
No,
these
maybe,
things
but
are happening in,
May-
I
maybe.
don't know whether this is a government school or what.
That I'm not
If
aware.
it is government school, that is all right.
No,
There
this-
cannot be.
We don't know
Well-
whether it's a government school.
And
But I
very
can't say.
serious view was taken at that time by the,
No, it's okay, but your APP cross-examine him.
yes.
He'll give you the entire set.
Sir, may I say that one copy may be given to us also? The certified copy was not given there. also.
No, a certificate copy was rightly not given. But Mr. A. Ahmed, counsel for the appellant, and Mr. D. Das Lanet, APP for the state. Next para. In this appeal, the appellant took a plea of juvenility on the date of offense, and accordingly an inquiry was ordered. Stop. The inquiry report of the inquiry conducted by Special Judge Darang Mangaldai has been placed before the court. In order to enable the learned counsel for the appellant as well as the learned APP to address the court, the criminal level section shall provide a copy of the forwarding letter of the Special Judge Darang Mangaldai dated 19/6/2023, along with inquiry report and other documents appended thereto. The learned counsel for the appellant and the learned AVP. This is the matter after
2 weeks.
2 weeks.
Not 2 weeks, also may I pay for Monday or Friday? also?
No, one day
Because-
they'll have to take instructions.
Yeah, otherwise I will pay for bail because prima facie it is there and section 12 will come. Also. If prima facie it is not-
We'll have to give time. The next week is almost close. He'll have to take instructions and then address the court.
Only my prayer because also it is already there in the.
No,
report
no,
that he is
but
given.
you see, I'll have to give an opportunity to him. He must take, because this, he's pointed out question as to whether the school is a government school or not. He'll have to take instructions, and this being an appeal, he'll not get it from the IO.
Next week was on 17th, very possible. 7th.
We'll make it 21st. Let him, because the offices don't work on this 15th, for the 15th August, 3 days, there will be no working. Even I don't know if all the lawyers will be attending on 14th. That also we don't know. Sandwich between 2 holidays. Correct.
21st.
20, make it 21/8/2023.
Right.
This by state.
Yes. This was filed by Ms. Zahan. And this is before code number 1 to them. Could it be taken up on summer of the,
Just a moment.
I don't know.
Already leave
No,
it
here,
granted and,
Why
the
did we list it today?
LCR is
LCR
received.
is
You
received.
have to direct the paperwork to be prepared.
yes, that direction.
Yes, that can be done.
And they may be directed to furnish the copy of appeal memo also that is not given to us.
Appeal memo I will give.
Okay. Mr. D. Das, learned AVP, appearing for the appellant shall provide a copy of the memo appeal to respective learned counsel appearing for the respondents. You just write your name in a piece of paper and give it to him so that he remembers and give it to you. Your phone number and those, so he'll give it to you. Next, see in the office note dated 3/8/2023 indicating that LCR has been received. So accordingly, the registry shall prepare a paper book. Next, list after 4 weeks awaiting preparation of paper book. Acha, make it Mr. You're from? Who's for 1 and 2? Mr. VH or V for 1 and 2. 3 is Mr. SH Rahman.
And 4, 5, 6 and 7.
4, 5, 6 and 7, Mr. Ahmed.
Yeah.
Just record the presentation.
16 and 17.
Please, your lordship. My lord, this matter actually came up on 31st. When, my lord, in another IEA number 1998 of 2023, in the next item, that is item number 17, my senior colleague had sought for some time to file affidavit. This IEA was not registered by them, although we're filed together. Now this IEA has also come. My lord, basically, these 2 IEAs have been filed in the respective appeals, which the husband has filed, challenging the decree of restitution of conjugal rights and the rejection of judicial separation. The appeals were pending during the pendency. The application that has been filed by the wife before the Learned Family Court seeking divorce. Now, literally, that concedes my lord, my appeal. So, in that view of the matter, we have filed these 2 IAs, to which my lord, my senior colleague has sought for some time to file affidavit in one of the IAs. The other I has come before this honorable court first time.
You're for the husband.
I'm for the
And you're,
I am for the wife.
you're for the wife. Now you have filed an application for divorce.
Divorce. Because my lord, I filed the restitution application, which was decreed. And that decree was not executed within 1 year. As per section 13(1)(a)(2) of the Hindu Marriage Act. Then I can file the petition for divorce.
So then instead of keeping this matter pending, you
Oh, there is one more appeal. And a separate set of counsel are there for the other appeals. Mr. PJ Saikia and B. Borgohain. In fact, lordship appeal is one lordship, one is jail appeal. Subsequently, they appeared for the appellant. So 2 appeals for same person, one is jail appeal and one is regular appeal.
No, there are 5 accused persons in
And,
total.
and
Huh.
third one is for other accused persons.
okay. So this the jail appeal
Yes,
was by Raju Satnami.
yes, lordship.
So I think when he's filed a regular appeal,
Yes.
I think
As far as Raju, she can appear, but in case of other
no,
appellants.
but
Huh.
this in the other appeal, Raju is not there.
No,
One
no,
is
he's not
for
there.
Raju also. Three
Saju,
appeals are there.
Huh,
One is for Raju also.
other appeal, Raju is not there.
huh. So
Huh.
only one is for Raju.
Huh.
So,
I am for Raju in jail appeal, but one is regular appeal is also by Raju.
oh,
Three,
acha.
three
So
cases.
then the jail appeal will have to be closed,
Lordship.
is it not?
Yes, the engagement was later.
No,
Initially,
whatever-
it was, yes.
No, whatever be, but
Ah.
if the,
Lordship can hear both.
no, that would be difficult.
Hmm.
Her argument may be different from the appellant. Then what happens? Supposing she is arguing for acquittal and the regular counsel comes and admits that
Hmm.
he has done the crime, then what happens?
Consider all.
Huh?
Lordship will have to, in that case, because there
No,
are.
we don't know.
Hmm.
Last occasion he was there. Today it is fixed, Lordship. On the last occasion they were there. And today morning also I have seen him in the court.
No, just a moment. In this criminal appeal 150,
There are 4 accused.
Saju,
Hmm.
Sunki,
Hmm. Deveshwari,
Deveshwari
Veena.
and Bina. So Raju is not there.
Another
is
one
not
is
there.
there. Criminal appeal 158.
158, Raju has filed it separately.
$158.
Because the ultimate blow was given by Raju. So that is how the councils have separated.
Okay.
Because Raju had killed her ultimately in the hospital before the doctor and the nurses. And these 4 had a quarrel in the morning hours. I mean, 2 hours before the actual incident. That is why he had separated.
Then what we propose to do is today, since Mr. P.J. Saike is not present, we'll appoint Ms. B. Sharma as amicus curiae in the other 2 appeals also and then hear it.
Can. And
Because
PJ
she's
Saikar
already-
might come also, no? She saw.
His name may be reflected to in the notice, Lordship, then because he is here in the court. Today morning I have seen him. And
Acha.
today is fixed date also.
P.J. Saikia,
Yes.
item 21, 2021. Okay, we'll wait for some time.
Lordship.
If he does not come before we rise at 1 o'clock,
If necessary, I can see him in his.
no, it's okay.
chamber
We are
also.
giving him. But if he does not appear, then we appoint you as amicus curiae and then proceed with the matter on the next date, since you have already prepared.
But
25.
Mr. B. Dalukdar is on his way. He's saying.
Sir, he is coming. He is under the court. Sir, Vitaludra is coming.
He's coming, okay.
The appellant is inside for 7 years. The appellant is inside for 7 years, 8 months.
This only factor which has come here is that one of the witnesses have said that he was under the influence of alcohol.
Hmm.
Is there a medical report to that effect?
No, no, medical report, and unless he is forcefully given that alcohol, that case cannot come under the exceptions.
Will not come in the exception.
It's given in the CRPC. He has to be forcefully administered the alcohol.
Okay. So otherwise,
Will not come,
it's not a good defense.
and not a good difference.
No, except for that, it's not a very good case. For acquittal, it's not a good case.
Section logic can see the alcohol, administering alcohol forcibly. Yes. Section 85 of the IPC. Section 85 of the IPC.
Without his knowledge.
Nothing is an offense which is done by a person who at the time of doing this, by reason or intoxication, by reason of intoxication, incapable of knowing the nature of the act, or he is doing it what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. So he was simply drunk here, and so he did it. Oh.
I'm very sorry.
Yes,
my
Mr.
lord,
No,
I
it's
was on
okay.
breaks in court, my sir.
It's okay.
Lordship, the Ejahar, your lordship will find at page 4. Page 4. To the officer in charge, so and so, so and so. So the humble submission is that during night hours on 6/12/2015, Deepali Kachua, who used to walk in my garden, passed away. I came to know about the incident in the morning on 7/12/2015. It is learned that her husband, Charua Kasua, alias so and so, killed her under the influence of liquor, and thereafter he fled, taking his 8-year-old daughter along with him. I got the PM examination done and made arrangement for her cremation. I therefore pray you to take necessary action upon investigation into the matter. Lordship, there are as many as 9 witnesses examined by the prosecution by them, and none by the defense.
There is no eyewitness.
There is no eyewitness.
Only the confession statement is there.
One confessional statement and subsequently it was retracted under 313.
Huh.
The statement was retracted. Confessional statement, your lordship will find at page 30. It starts from page 30, my lord. And page 32, Roman 5. My wife consumed liquor. She had extramarital affairs with other persons. And then your lordship will come to page 33. My wife, Dipali Kachua, had been consuming liquor daily from the last 7-8 months. I prevented her from consuming liquor. On many occasions, Dipali chased me to assault as I asked her not to establish physical relationship with other persons. Because of that, there had been frequent quarrels between Dipali and me. On 6/12/2015, Dipali came home in an inebriated condition. She again wanted to go to consume liquor. Then I prevented her from doing so. At that time, she caught hold of my penis tightly with her hand and she tore the buttons of my shirt. Then I pushed her and made her fall on the ground. I got engaged. I got enraged as I was also under the influence of liquor. Then I dealt 4-5 heavy blows on Dipali's head with a bamboo stick. She got fracture on her head and blood was oozing out of her head. Dipali died on the spot. This was the confession.
Place of death was the house.
House.
Somewhere it has come out that it was jungle also.
Nearby there was jungle because it is tea garden labor land.
Okay.
Then your lordship will come to page 27. Page 27, we retracted the statement. '25 is starts, which is under section 33 of CRPC. Question number 2, question number 2, that is in page 26. Dr. N.C. Bhuya has further stated in his evidence that accordingly on 11/12/2015, you were produced from the jail and were again explained that you are not bound to make confession and that if you do so, it may be used as evidence against you. However, you stated that you wanted to make the confession and as such, you were placed under the custody of supervision of so-and-so court peon from 3:30 p.m. to 4 p.m. for reflection. What is your reply in this aspect? Answer is I am innocent. Then my lord, question number 3. At page 26, question number 3. PW 9, Dr. N.C. Bhuya has further stated in his evidence that at 4 p.m. on the same day, you were again asked to whether you want to make confession or not. But you stated that you were willing to make the confession, and then you were explained that you are not bound to make any confession, and if you do so, it may be used as evidence against you. After that, as it was found that you wanted to make your confession voluntarily, the confession was recorded in his presence and hearing and also read over to you, and you admitted that the statement is correct. The confession contained the full
and true account of statement made by you, and you were in a fit state of mind. After that, the bench assistant of the court took your signature in his presence. Thereafter, you were remanded to judicial custody. Exhibit 6 is the order dated so and so. 6(1) is his signature. 7 is the order dated 11/12/15. Exhibit 7(1) is signature. 8 is your confessional statement. 8(1), 8(2) are his signature. 8, 3, 4, 5, 6, 7, and 8 and 9 are your signatures. What have you got to say in this regard? Answer is, I am innocent. Police coerced and tortured me to make confessional statement. This was his subsequent statement under 313. The judgment minute starts from page 37. Mary.
Yes.
Page 37, it starts. The prosecution case unveils that with the affair dated 8/12/2015 lodged by one Manoj Kumar Misra with the officer in charge of Dimapur CPS, to the effect that on 6/12/2015, one laborer of his the estate, namely Dipali Kachua, who died on 7/12/2015. The incident was apprised to him. He came to know that the Dipali Kachua who was killed by the husband Sarua Kachua on the influence of liquor, and thereafter he fled away along with his 8-year-old daughter. Pursuant to the FIR, the officer in charge, Dimapur CPS, registered the case being number 63 of 2015, dated 8/12/2015 under section 302. And launched the investigation of the case. During the course of investigation, the investigating officer visited the place of occurrence, recorded the statement of available witness under 161 CRPC, prepared a hand sketch map of the place of occurrence, held inquest on the dead body, and thereafter the dead body was brought to the Udalguri Civil Hospital for postmortem examination. The accused was arrested and forwarded to judicial custody. They seized 3 pieces of split bamboo at the place of occurrence, and the investigating officer collected the postmortem report. On completion of the investigation, the police submitted charge sheet against the accused, so and so, under section 302 IPC. The learned chief judicial magistrate accepting the charge took cognizance of the offence and ensured that the attendance of the accused. Thereafter, the case was transferred to the file of the learned SDJM Udalguri, who, upon perusal of the case record, having found the offence under section 302 IPC, being exclusively triable by the Court of Sessions, committed the case to this Court of Sessions on 12/6/2017, as per mandate of section 207 of CRPC. On commitment of the case along with the relevant documents and upon evaluation of the copies of document supply under section 173, my learned predecessor in office, having found the prima facie case an adequate material to frame charge against the accused so and so under section 302, frame formal charges there. And the same on being read over to the and explained to the accused, to which he pleaded not guilty and claims to be tried. To sustain the charge, the prosecution has examined as many as 9 witnesses, including the informant, MO, and IO of the case. In addition to thereto, the prosecution also relied on some documents marked as exhibit. Defense of the accused is of innocence. His case, as it could not be ascertained from the trend of cross-examination of the prosecution witnesses, suggestion and his his examination under section 313, it is that of false implication. Accused has also denied to have any confessional statement voluntarily. However, the accused declined to adduce defense evidence in support of his plea. In the context of the above facts and circumstances of the case, the point of determination in the case is set forth as follows: whether the accused on 16/6/2 at night village Athirikhat jungle under the Democracy PS committed murder by intentionally causing death of the Dipali Koswal and thereafter committed an offense punishable under section 302. I have heard argument canvassed by the learned counsel of both the sides and also minutely scrutinized the evidence on record in entirety to arrive at my finding. Then the Honorable Court discusses about the witnesses. My lord. But none of the witnesses, there is no eyewitness, man.
No, there is no eyewitness.
No eyewitness. And Lordship may come to paragraph 25.
Each
My 25 of the
25.
judgment, from the judgment. In the present case in hand, there is no eyewitness to the occurrence except the confessional statement of the accused recorded under 164 CRPC, which was later retracted by the accused during the examination under 313 CRPC. In that view of the matter, it would be exposited to find whether the confessional statement of the accused would be acted on if it is substantially corroborated by independent circumstances. Since there is no eyewitness, my lord, it has to be corroborated. Then 26. Before proceeding further, it is also worthwhile to mention that criminal jurisprudence begins with the presumption that unless otherwise proved, the person facing the trial would be deemed to be innocent. The burden of proof, the charges against the accused is on the prosecution and not on the accused. The prosecution, if fails to connect the act of the accused with ultimate crime and where the materials links constituting the chain of circumstantial evidence are found missing, then the benefit of same goes in favor of the accused. Every criminal trial is based on direct and circumstantial evidence, whereas the former directly establishes the commission of an offense while the latter does so by placing unbroken chain of circumstances which can lead to irresistible inference of guilt. In the fact of the present case, there is no direct evidence to prove the commission of charge of murder by the accused person, the appellant hearing, and the case primarily rests on circumstances only. It is a trial law that where the case is based on circumstantial evidence, the circumstances from which the conclusion of guilt is to be drawn should be the first instance be fully established. And all the facts so established should be consistent with the hypothesis of guilt of the accused. Again, the circumstances should be conclusive in nature and they should be such to exclude every hypothesis but one proposed to be proved. In other words, there must be a chain of evidence so far complete as not to leave any reasonable ground for conclusion consistent with the innocence of the accused, and it must be such as to show that within the human probability, the act must have been done by the accused. So and so, so and so. The said principle is set up by the apex court to have been reiterated time and again in one or other form by the various judgment of the apex court. And then lots of come to paragraph 32. As to what should be the legal approach of the court called upon to convict a person primarily on the light of the confession or a retracted confession had been summarized in so and so, so and so. Confession can be acted upon if the court is satisfied that they are voluntary and that they are true. The voluntary nature of confession depends upon whether there was any threat, inducement, or promise, and its truth is judged in the context of the entire prosecution case. The confession must fit into the proof fact and not run counter to them. When the voluntary character of the confession and its truth are accepted, it is safe to rely on. Instead, a confession, it is voluntary and true and not made under any inducement or threat of promise, is the most patent piece evidence against the maker. Retracted confession, however, stands on a slightly different footing. As the Privy Council once stated, in India, it is a rule to find a confession and to find a retracted letter and to find it retracted later. A court may take into account the retracted confession, but it must look for the reasons for making the confession as well as for its retraction, and must weigh to determine whether the retraction affects the voluntary nature of the confession or not. If the court is satisfied that it was retracted because of an afterthought or advice, the retraction may not weigh with the court if the general facts proved in the case and the tenor of confession is made and the circumstances of its meeting or withdrawal warrant its user. All the same, the court did not act upon the retracted confession without finding assurance from the same other sources as to the guilt of the accused. Therefore, it can be stated that a true confession made voluntary may be acted upon with slight evidence to corroborate. But a retracted confession requires the general assurance that the retraction was on the afterthought and that the earlier statement was true. This was laid down in court in so and so, so and so.
But in this case, if you come to page 50, paragraph 40, page 50 of the paper book.
Paragraph 40.
Yes, in the middle, you will find a bit below that middle part.
Right.
Thereafter, the accused was remanded to judicial custody for 1 day for reflection.
Yes.
And again
Those-
on
those-
11,
Right.
again on 11, he was produced from jail and he was explained that he was not bound to make confession. Thereafter, it was in the custody of the court peon. And then he made confession. Now, in the while retracting from the confession, he said that he was coerced by the police and he was tutored. And then he gave the confession. But that would fail because of the fact that he was in judicial custody. He could not have been.
Custody, and then for 2 days, then he was produced before the court. The reaction time was given to him. Everything was procedural part was done. So if that is taken to be true, the confessional statement, my submission will be on that line, my lord, that if that is taken to be true, it may not be a case under 302, my lord, maybe exceptions of 300 and 304 maybe. Because my lord, in a heat of a moment, because he was, probably that is not an excuse, you were under the influence of alcohol, but his wife he was also under the influence of the alcohol, and there was a sudden quarrel took place between them. Then at the heat of the moment, my lord, he had given the blows. So my submission will be on that line.
Well, this grievance, sudden provocation must to some extent be proved by the accused or any mitigating circumstances from the evidence from where you can call out that this was a case of grave and sudden provocation. Because this happened in the confines of a house.
There was no eyewitness.
There was no eyewitness.
So after the incident, the person was not there. He fled away.
He fled away with the son.
With daughter. Then he was caught hold of by some village people and handed over to.
He was caught by AATSA, ATSA.
Atsa people and handed over to the police.
Or some T tribe.
So inside the house, what happened, probably nobody could say that. Most of the witnesses also, they came later. After hearing the incident, they came later to the spot and found that the she was lying dead. So if that be the case, my lord, if the confessional statement is taken on account by the court below, my lord, then my lord, it may be a case, my lord, that is my certificate. Maybe a case of sudden provocation.
Evidence Act. Yes.
My lord, then we then come to paragraph 52 and 53.
Paragraph
52.
52, 53.
However, in the instant case, exhibit 8, the confession of the accused assumed importance as the accused himself has translated his mental disposition as to the motive of the committing murder of his wife, stating overwhelmingly me that he suspected his deceased wife maintaining illicit relationship with other person, as a result of which frequent problems had taken place between him and the deceased wife. But his wife did not listen to him, which appears from the apparent motive of the commission of murder of his wife by the accused by hit on her head 4 or 5 times with a bamboo stick by force resulted her instantaneous death. The inevitable conclusion that necessarily follows reliable confession of the accused being corroborated by important chain of circumstances in attending facts and circumstances of the case, as disease above have been proved by credible and unimpeachable evidence. To put it differently, the cumulative effect of the confession of the accused and circumstantial evidence as discussed leads to the unmistakable conclusion that the disease was done to death by the accused alone. Then my lord, paragraph 61. 61 at page 56. The principle of law which has been laid down in the aforesaid judgment would apply in the instant case, as the accused has not offered any explanation that how and what circumstances murder of his wife Deepali was committed in his house. In other words, what had happened after the evening of date of the occurrence, particularly when, if at all, the accused parted in the company of disease on the next early in the morning by absconding from house, were fixed within the special knowledge of the accused. It was the accused to explain these facts, but instead he became complete denial and statement of the 313. The mere denial of the prosecution coupled to the absence of explanation offered by the accused, I hold to be inconsistent of the innocence of the accused, but consistent of the hypothesis that the accused is a prime accused in the commission of murder of his wife, who was found dead in his house. It was the accused who was last seen in the company of the deceased at his own house, to explain the circumstance in which he parted the company. The failure of the accused to do so must cause the valence as failure to explain facts which was within his special knowledge. On cumulative consideration of the
Mr.
material-
Talukdar, you'll find this the issue which you are the paragraph 61 which you are pointing out.
Well,
Please come to 106.
burden of proving fact is present within the knowledge. When the fact is within knowledge of any person, the burden of proving the fact is upon him.
Then there are two illustrations. That will make it clear.
When a person doesn't act with some intention,
So this observation made in paragraph 61, the basic principle is that. Huh.
Yes. Upon that only, but my lord, there are two One thing is, my lord, the bamboo stick which were seized, but which the weapon, which were used as a weapon to kill. That was not sent for. Whether the blood was there in the stick, and that was never sent for. That is one aspect. Secondly, my lord. Now, the entire judgment raised on the confessional statement as it appears, my lord. Then, my lord, there may be, my submission will be that there may be some sudden provocation. Which leads to me not attract the provision change. And that apart, my lord, he had already gone about 8 years ago.
Because you see, there is another way of looking at it. This confessional statement gave the motive which was not there otherwise. And the difficulty is that when it is 302, we have a minimum punishment. The question of 8 years or otherwise would not be a relevant factor.
It is my continuation of my submission that it may be under sudden provocation and heat of the moment.
304. Because 304 part 2 would have been there, but there was a necessity for him to say something in his 313 statement or give evidence. Staying in 313 is not enough. But if evidence had been led, that this was the ground. Mr. Das, can without that evidence being led, how do you perceive this submission of having this converted into 304 part 2? Because apparently something had happened which resulted in the commission of crime. There is no eyewitness.
Eyewitness is not there.
And as per the confession that the wife was maintaining extramarital affair.
And she used to quarrel with him.
She used to quarrel with him, and that is a part of the confessional statement.
That is, with all respect, I submit, that is his plea.
No, but it's a
This is
part of
plea,
confessional statement.
Number one. Number two, my lord, he has rejected the confession at the fag end of the trial. Under section 313 of CRPC, while his statements were recorded.
No, I'm only on one principle. Because when when we are considering a confessional statement,
My lord.
the fact that the wife had a extramarital affair is an inherent part of that same statement.
No, that cannot be taken into account.
So grave and sudden provocation, which may lead to what you call, can have it converted into 304 part 2.
304, so far 164, I mean, the confessional statement is concerned, my lord. Now, that is a plea. That why his wife was such as kind. But to that effect, if that plea is taken, my lord, he has to produce evidence to that effect. None of the prosecution witnesses have been cross-examined on that effect. That whether defense did never cross-examined. No suggestion at all was given. So that is why, my lord. Now, yes, your lordship may very much ask a question that if the confessional statement consists of inculpatory statement and exculpatory statement, both are there, then whether it can be, my lord, the exculpatory statement can be ignored, and for the purpose of conviction, inculpatory statement can also only be taken into account. In that case, my lord, that is 1969-19 Nishikanta Judge case is there. If the, my lord, exculpatory statement is highly improbable, in that case, that can be ignored. an inculpatory statement can be the basis of conviction. That being the position, he has not.
Continue at 2.
Yes.
Yes.
So minor in a nutshell, that is my submission.
If it can be converted into 304 part 2. Yes, Mr. Das.
My admittedly, there is no eyewitness to the occurrence. Number one. Now, the confession is the main evidence in this case. The confession consists of two. That is, one is exculpatory statement and another is inculpatory statement. Now, so for exculpatory statement, that is, he says that she was not asked by the husband, I mean accused, that not to keep on physical relationship with other, and she was consuming liquor for 7-8 months continuously, and she used to quarrel with him. But a good number of neighbors were examined as prosecution witnesses. Not a single, not about cross-examination, even no suggestion has been given to that effect to the prosecution witnesses. Number one. Then as soon as such defense is taken, plea is taken by the defense, burden is shifted to him. He has to prove it. And he has not examined any defense witness for proving that contention. So that plea is not available to him now. Now, the confession was retracted subsequently. Confession was retracted, but your lordship will find here confession was made on 11/12/2015. That is after 5-6 days after the occurrence. And retraction was made on 14/6/2019. I think. That is at the time of 313 examination. Now, whether this belated retraction can be taken on account by this honorable court. But to that effect, apex court has also said, and there is a judgment of our high court also, that belated retraction should be made at the earliest opportunity. That is the law, at the earliest opportunity, if the person concerned want to retract from his confession. But here, after 4 years, he was examined under section 313 on 20/11/2018. This is after 3 years.
This
So
confessional statement is 9/2/15.
9/2. No, 1 second. 11. I think.
31.
9/2/15. Page 30.
It's 30.
Page 30.
No, it was recorded on perhaps 11/12. 11/12 12/2015, page 34, my lord. That is the signature of the learned magistrate who recorded it.
Oh, acha. 11,
Page
12.
34.
11, 12. Huh,
11.
Right. 11, 12. 11, 12, 13, yes.
Yes. And reflection was on the date of examination under section 313.
And this is 14/6/19.
14/6/19. 14/6/18.
14/6/19.
19, 14/6/19, page 27.
Yes. Yes, 14/6/19. So after 4 years, about 4 years,
3.5 years.
3.5 years, 3.5 years.
Okay.
Now this is one aspect. Number two, my lord, after occurrence, he fled away along with his key. This is a conduct on the part of the my lord accused appellant. Post occurrence conduct, which has to be taken into account. Now, why he fled away? His wife has expired, and he fled away. So that
Section-
indicates his guilty mind, my lord.
Section 8.
Section 8. So, my lord, keeping all these evidence on record, with all respect, I submit, the Lana trial court has not committed any error in convicting and sentencing the my lord, accused appellant.
You
Will be dictating.
partly I'll dictate it, the facts I'll dictate so that,
Can I be excluded?
yes,
The
yes.
matter reads.
yes.
The
Yes,
part
yes.
matter.
Uh-huh.
I'm reply of that.
I'll just dictate the facts so that it's
Might-
easier
will
for
be
us.
same.
You type it and give it in pen drive to my secretary. Huh? Heard Mr. Bijay Talukdar, Senior Counsel and amicus curiae in the matter, assisted by Miss
You, Augustine.
You,
Augustine, AUGUSTY.
Augusti.
AU,
AUG.
just write it down. Huh? Just write down. I'm not getting you. Learned Counsel. Also had Mr. D. Das, learned additional PP for the state. Next para. This appeal under section 374 Ms. Janti, these appeals are registered under 374 or under 383?
383 is a jail.
Only
appeal.
procedure part.
No, 383.
This will be
383 is jail
Yes,
appeals
this
are
is
under
jail appeal.
383. 374 will be state appeal or.
No,
company.
regular appeal.
Regular.
So this will be 383.
383.
I should write appeal under 383. This appeal under section 383 CRPC by the appellant from jail is referred against the judgment and order of conviction dated 19/7/2019 passed by the learned Sessions Judge Udalguri in Sessions case number 43 of 2017, thereby convicting the appellant under section 302 IPC and sentencing him to undergo imprisonment for life. Next para. One, Manoj Kumar Mishra lodged an FIR dated 8/12/2015 with the officer in charge, Dimakuchi, DIMAKUCHI, PS, to the effect that on 6/12/2015, one Dipali, DIPALI, Kashua, KACHUA, within bracket Kujur, KUJUR, bracket closed. A labor in his tea estate had died on 6/12/2015. Full stop. However, he was informed of the incident on 7/12/2015. He is that the officer in charge of Kashwa PS must have accordingly Dimakuchi PS case number 63 of 2015 dated 8/12/2015 was registered under section 302 IPC. Full stop. In course of investigation, the on finding sufficient evidence against the appellant, charge sheet was submitted against the appellant. What is the charge sheet dated?
Exhibit 5, page 72.
What is the date?
Date. 31/8/2016.
31/5/2016. Was submitted against the appellant. Stop. The learned Chief Judicial Magistrate Udalguri accepted the charge sheet and the committal proceedings was transferred to the Court of Learned SDGM Udalguri who found the case exclusively triable by the Court of Sessions and committed trial to the Court of Sessions by order dated 12/6/2017. Stop. In course of trial, the prosecution had examined as many as 9 witnesses, not as many, 9 witnesses. Their names you'll find in page 54. Just write like this: Dr. Chandan Kumar Saha, Dr. Chandan Kumar Saha, within bracket PW1. Then give a semicolon, and then number 2, 3, 4, 9 till. And the following documents were exhibited. VIZ, post of Hama, postmortem report within bracket exhibit 1, EXT, exhibit is EXT, full stop 1, numerical 1. It goes up to 8, exhibit 8. You will find it page 24. Full stop. Thereafter, the appellant was examined under section 313 CRPC. Who denied all the who denied having committed the offense, and also denied that he made the confessional statement voluntarily. Mr. Hava, the defense did not examine any witness. Full stop. Next paragraph. The doctor who had performed the postmortem on the dead body of the deceased was examined as PW1, and as per his report, within bracket exhibit 1, EXT 1, he had recorded the following injuries on the dead body. Give a comma, then number 1. Big lacerated injury 10x4 cm on the scalp, comma, number 2. Fracture of occipital bone, OCCIPITL bone, comma, skull bone exposed, comma, fracture of right temporal, TEMPORAL bone, and fracture of right mandible, MANDIBLE. And had opined that death had occurred due to head injury caused by blunt object, giving the time of death about 18 to 10 hours before. Full stop. The defense did not cross-examine the PW1. Full stop. None of the witnesses examined by the prosecution are eyewitnesses. Full stop. BW2, who had lost who is the first informant in the case, had exhibited the FIR within bracket exhibit 2 containing his signature and had stated that the occurrence took place on 16/12/2015 and he was informed of the incident on the next date. Stop. He rushed to the place of the occurrence and saw the victim lying in a pool of blood with injury on her head. And he found the appellant missing from the house. Thereafter, he lodged an FIR. He had stated that the police had seized a lathi, a bamboo stick in the house of the accused in his presence and prepared a seizure list, which was also exhibited by him as Exhibit 3, EXT 3. Stop. As per his cross-examination, the house of the PW2 was situated about 500 meters away from the place of occurrence. Full stop. PW3 resides near the place of occurrence. And on coming to know about the incident, he rushed to the place of occurrence and two persons present there informed him that the appellant has left his house after killing his wife. Stop. In his cross-examination, it was stated that his house is at the distance of 200 meters from the place of occurrence, and that he had not received any information at the night. Stop. PW4 is also hearsay evidence and heard about the incident. An incident of quarrel between the appellant and his deceased wife under the influence of alcohol, and had stated that the appellant, after killing his wife, had absconded. Stop. You can leave.
That matter is over.
Okay. Stop. In his cross-examination, the PW4 had stated that he had no personal knowledge of the incident. Stop. PW5 is a seizure witness. Stop. As per his statement in the examination in chief, he saw many people gathered in the house of the deceased, and so the deceased lying there with injury on her head, and he heard that the appellant had absconded after killing the wife. Yeah, the appellant was not seen after killing his wife. And the bamboo lathi was seized in his presence. And he proved his signature in the seizure list within bracket Exhibit 3, EXT 3. Stop. In his cross-examination, the PW5 had stated that he does not know how the incident took place. And he did not see when the appellant had absconded from his house. So, PW6 also did not see the incident. He came after the garden owner had called him. And he went to the place of occurrence and saw the dead body of the victim. And the appellant was not found in his house as he had fled away. Stop. He had stated that the appellant was caught by the member of AATSA, and he saw injury on the head of the deceased. Stop. In his cross-examination, PW6 had stated he does not know how the deceased had died. Stop. PW7 also did not see the incident. On the date of occurrence, he had gone to the house of his relative, where he heard that one woman was killed. The defense did not cross-examine the said witness. Next paragraph. PW8 is the investigating officer. So on 7/12/2015, while he was posted as the in charge of Khograbai, KHAGRABARI police outpost, he was informed over telephone that a female dead body was lying at Athari Khat, ATHARIKHAT jungle. And therefore, after recording GD entry number 91, dated 7/12/2015, he went to inquire about the matter. In the meanwhile, the circle inspector, the circle officer, and the officer in charge of Dimakuchi, DIMAKUCHI police station had already arrived at the spot. He had stated that the inquest was conducted by the circle officer, and thereafter the dead body was brought to Udalguri Civil Hospital for postmortem examination. He had recorded the statement of the witnesses under section 161 CRPC. Did the preliminary investigation of the case on the basis of GD entry recorded earlier, prepared a sketch map of the place of occurrence and send the accused to judicial custody. And he had also seized 3 pieces of split bamboo at the place of occurrence. On finding prima facie case against the appellant, charge sheet was submitted by him. the PW8 had exhibited the seizure list within bracket exhibit 3, sketch map within bracket exhibit 4, and chart sheet within bracket exhibit 5. So in his cross-examination, he had stated that the appellant was not found at the place of occurrence at the time of investigation. And also admitted that the extract of the GD entry was not made a part of case record. And it also stated that the seized split bamboo was not sent for serological examination, SEROLOGICL examination by the FSL. Next paragraph. In this case, a confession was made by the appellant, and the judicial officer who recorded the confessional statement of the appellant was examined as PW9. First of, as per his statement, the appellant was produced before him on 9/12/2015, and he had sent the appellant to judicial custody, giving him time for reflection. After informing him that he was not bound to make a confession, and if he does so, the same may be used against him. And while doing so, a legal aid counsel was also engaged. Full stop. Thereafter, on 11/12/2015, the appellant was produced from judicial custody, and he was once again put to notice that he is not bound to make confession, and that his confession may be used against him. PW9 had stated that the appellant still wanted to make confession, and thereafter he was kept under the custody and supervision of a court peon named therein from 3:30 p.m. to 4 p.m. for reflection, and thereafter the confessional statement was recorded. After once again informing the appellant that he is not bound to make confession, and that if he does confession, if he confesses, and that his confession may be used against him in the trial. Full stop. It was stated that the confession was voluntary, and the appellant had put his signature after accepting the statement to be correct. Full stop. He had proved the order dated 9/12/2015 as Exhibit 6. Order dated 11/12/2015 as Exhibit 7. And
Exhibit 8 was the confessional statement of the appellant containing his signatures. Full stop. Next paragraph. The learned trial court, taking into consideration the evidence of the witnesses, specifically the 5 injuries sustained by the deceased, arrived at a finding that there was no ocular witness to the accident, to the incident. First, the learned trial court took into consideration the retraction of confession made by the appellant while he was being examined under section 313 CRPC. And upon discussion, the discussion of the case laws on the subject, considered fact that the appellant was put to notice that he was not bound to make confession and that the confession may be used against him. Arrived at a conclusion that the confession made by the appellant was voluntary and was a truthful statement of what had happened at the time of incident. In this regard, the learned trial court also took notice of the fact that the defense had declined to cross-examine the PW9 who had recorded the confessional statement by Exhibit 8. Full stop. Accordingly, the next paragraph, accordingly, the learned trial court accepted the confessional statement and discarded the defense of the appellant being drunk on the ground that voluntary drunkenness is not a defense for commission of a crime. And also arrived at a conclusion that the injuries found in the dead body tallied with the injuries mentioned in the confessional statement by the Exhibit 8. And found that the evidence of the witnesses, specifically the PW 1, 2, 4, and 5, insofar as the nature of injury suffered by the deceased and took notice of the
evidence of the PW. Even 5. That bloodstained lathi was seized by the exhibit 3. And also took notice of the moreover, the fact that the appellant had absconded from the house after the incident. Accordingly, on the ground that the incident had taken place in the house and that the and that the appellant was unable to explain how his wife was dead, had died. And therefore arrived at a conclusion that instead of explaining what the circumstances under which his wife had died, chose a complete denial as a defense. And it was held that a mere denial of the case of the prosecution and the absence of any explanation offered by the appellant, it was held to be inconsistent with the plea of innocence of the appellant. Accordingly, the appellant was found guilty on cumulative consideration of the materials on record. By relying on the confessional statement made by the appellant and held that the appellant was guilty of commission of offense under section 302 IPC. Thereafter, the appellant was heard on the sentence and accordingly the appellant was sentenced to be imprisoned for life under section 302 IPC. Next page. The learned senior counsel appearing as amicus curiae had submitted that none of the witnesses were eyewitnesses to the incident and that the IO had failed to send the split bamboo stick to FSL for forensic examination. Hence, it is submitted that it was doubtful as to whether the bamboo, which was the split bamboo stick, was the weapon of assault. It is submitted that the confessional statement ought to have been discarded as the confessional statement was retracted while we stay, while the appellant was examined under section 313 CRPC. Was submitted that in the confession statement, it had come out that is that the deceased wife of the appellant was maintaining extramarital affairs and was also and the deceased also consumed liquor. For last 7-8 months. And that the appellant was preventing her from consuming liquor, and on many occasions, the deceased had chased him and assaulted him on being asked not to establish physical relationship with other persons. It is submitted that in the confession statement, the appellant had stated that there were frequent quarrels between him and the deceased, and that on 6/2/2015, the deceased had come home in an inebriated condition, INEBRIATED condition, and wanted to consume more liquor. And at that time, the deceased had caught hold of his penis tightly with her hand and tore the buttons of his shirt. And pushed her, which made her fall on the ground. And he had also stated that he was also under the influence of liquor. And he dealt 4 or 5 heavy blows on the head of the deceased with a bamboo stick. And accordingly, it is submitted that there were sufficient materials to show that there was a grave and sudden provocation on part of the deceased, which led to the assault by the appellant, who was also under the influence of liquor. Accordingly, comment is submitted that this was not a case of not a case where there was an intentional murder of the victim. And therefore, this was a good case to convert the conviction one under section 304. Part 2 is. And to set off the sentence with the with the period already undergone by the appellant. In this regard, we submitted that the appellant was arrested on 7/2. Seven. He was arrested on. He took 7/2/50. And is behind the bars since then for more than 7 years. Seven and a half years. Next one. Per contra comma, the learned APP has submitted that this is not a case where the retraction of a confession was made by the appellant at an earliest available opportunity. So he submitted that the confession statement was recorded on 11/12/2015, and the retraction came on 14/6/2019, i.e. after 3.5 years, while he was being examined under section 313 CRPC. Accordingly, comma is assumed that this was not a case of retraction at all.
Should I give the citation of our to 2011
In this regard,
to
the
GLT,
has referred to the case of
2011 to GLT 196, page 196. That is also reported in Criminal Law Journal, 2011 Criminal Law Journal.
It's okay, one
Same. Ram Singh versus State of Assam.
Ram Singh versus State of Assam. First, you write that name, Ram Singh, then citation. Right? First, it is for the submitted that the learned magistrate, before recording the confessional statement, had given the sufficient time to the appellant to retrospect. And on 3 occasions, he was put to notice that he was not bound to make confession. And the confession, comma, if made, comma, would be used against him. Accordingly, it is submitted that the learned trial court had rightly held the confessional statement to be admissible. Next paragraph. It is submitted that other factors which operate against the appellant is that after the incident, he had absconded, leaving behind the dead body of his wife at his home. So it is also submitted that although several neighbors were examined, but neither the extramarital affair of the deceased was proved, nor any ingredient was brought to show that there was grave and sudden provocation on part of the deceased, which led to assault made by the appellant. Accordingly, it is submitted that no case has been made out for altering the commission offense to one under section 304, part 2, IPC. From offense committed under section 302 IPC and to reduce the sentence to one. It was one already undergone. Correct, facts is okay. These are the judgment then. These are the facts, write the operative order. Heard so. Both names, heard Mr. Vijay Taluga Senior Counsel and Mr. Didas.
I'll be assisted by.
Yes, the names will be there. We have already recorded the names. Then you say, argument is concluded, judgment is out.
In fact, on that section 383, I found few decisions which says that an appeal under 383. And in certain cases, I've got appeal under 374 too, read with 383. So it can be either way, I think.
I think 374
4-2.
374 2, read with 383 would be.
Yeah, that's a procedure as the Lordship
That's
has
fine.
pointed out.
Appeal under 374 2, read with
383. That's a bit better.
This is the difficulty when CPC.
Doesn't apply.
No, when CPC doesn't apply.
That is also with me, my lord. This is a very new subject for me, probably for the second time I heard.
No, but you see, I'll show you something. I always show it in the court. But this is I don't know whether it is marked or not. But this is something I always show. And I'll tell you why. I'll first show to my brother. What's supposed to get most intelligent this? It is in the reading items. Then it says. The police got so you can say you have to go through this video. I don't know that's 15 years ago. So this is really acceptable that is this is don't know which this is just on a lighter side. No, to Mr. Taluga. This is a part of section 57. First page you'll find 57, section 57. Facts of which the court shall take judicial notice. Correct. Now you turn the page, you will find that there are 13 listed items of which the court shall take judicial notice. But I have marked something with pencil. The court may refuse unless you show me the book.
It has to be shown.
So therefore, you can't tell me. Me means my brother is included. I should be read as we. Now, you can't say that the law is there in this IPC, you find it. I may refuse to do so. Therefore, a judge is exempted from knowing law. Because the normal rule is that everybody, every citizen must know law. Doesn't apply to a judge. Correct. I need not know the law.
So therefore, judges.
Therefore, as a senior counsel, you can't say that it is a new subject for me. But I can take a defense.
Because in
That I don't
my
know the law.
entire career of 35 years, my lord, this is probably the second case.
Second. Just on the lighter side that I am exempted from knowing law.
Deeply obliged. sir.
So when people in the corridor say, "Judge doesn't know anything," he's right.
He's right. No, my lord, that folly gets realized, my lord, when he comes to this podium here and thinks that the judge doesn't know the law. And then when, my lord, somebody with that belief comes up and stands in this podium thinking that the judge doesn't know the law and try to say something except then he realizes the folly of that.
No, because you see, that will happen only because I have a great support of my brother.
My lord.
So then perhaps he faces the music, but
You know,
if my brother is
sometimes
not
when,
there, then maybe I don't know.
no, sometimes even sitting singly also, we have seen how people face the music. My lord, when they come with some absurd thoughts.
I don't know, but law
There
prevents,
there were instances. my
law
lord.
exempts you from knowing
Yes,
the law.
yes, my lord.
Me too.
19 to 21.
So already past 3 and Lordship has a single bench also, I think.
Yes.
But matter is not very long, but
No, but still, if I start, I'll have to conclude the hearing at least. I don't want to keep it parted and then send it on
Yes.
another day. Take it up another.
there are 10 witnesses, but
Well, there are
may
two
not
appeals.
very few.
One is 383, matlab,
No,
jail.
no. This with the single bench I am required to take. If I start hearing, criminal appeal will take me an hour at least. So I'll not be able to conclude today.
Yes.
So I'll not keep it parted. This is some other day.
Not a case of eyewitness also.
Second-
Not a case of eyewitness. In fact, the doctor or one boy had seen the accused coming out with a blood-stained machete. So only that,
Circumstantial evidence.
rest are circumstances.
Tell us when do we fix it?
Any day.
15th August.
16th August. Okay.
No, I have a problem on 16th.
On that day. Suggest me date.
Any date after that.
17th,
Recommencing 21st, then
21st August.
due to positive time matter could not be taken up today. First, right, all sides are present. As agreed by all sides. List the matter in the week commencing 21/8/2023. This, in this case, I did not check up the entire witnesses. The knife which was thrown in the river, was it retrieved by the police?
No, no, no. Not the blood stain plots of the petitioner, the accused person also sent to the FSL.
But then it was seized.
No, that is not very relevant.
Huh.
That is not very relevant because if the doctor says, matter, he shows the accused person going out of the room. There are other persons also, matter, who do not have seen.
No, that may be possible. You see, in the courtroom, when we are engrossed in reading the paper,
My lord.
I might not have noticed somebody coming in or going out, but you while sitting behind, you may not be engrossed in the matter, and therefore you have noticed who has come in, who has gone out.
Now, when
You see,
doctor say,
I'll tell you, if it comes to the evidence, I'll tell you how people react. Say, yesterday evening, after the court hours, I will say that I saw you perhaps in the green t-shirt. Correct. Green is a color which maybe Ms. Jahan doesn't like. So she might remember, no, not green. I think it was blue. Because when it is factored in the mind, the color which if I dislike it and I see it, I remember it. But if I've got no problem with any color, whether you are wearing a green or a blue doesn't matter to me. So therefore, I may not recollect the cloth which you were wearing.
yes,
One may say green, one may say blue. Like for example, I'll give you a very simple example, which I think you can understand. And she will also. You see, in my house, if we have to go somewhere, I would take up a pant and a shirt, I'll wear it. But immediately my wife will tell me, no. In their house yesterday, you went with the same cloth, change the cloth. My wife will also remember the nature of cloth which she wore in the party X, party Y. And then she will say that she will need a different combination. Correct. But I would not remember the dress which I had worn even yesterday, because it's not in my nature to remember that. But contrary, you will find people who are very conscious of what they are wearing, what they are not wearing, how they are grooming up. It's a part of their lifestyle. So they will remember, and they will remember the color.
my lord, that is good, my lord. When doctor says there are other persons also in the room, my lord, they were not examining you.
That's okay, definitely a lapse on the part, but you see, the question is that when one witness saw this person coming out from the house with not only with the bloodstained cloth, but there is also evidence to show that the knife was there and it was thrown in the river. The question is whether the non-examination of the
Vital
garment-
witnesses, my lord.
No, non-examination of the garment would it be fatal?
Apart from that, the other vital witnesses who may perhaps witness the offense committing, my lord.
It's okay.
Knife was never seized, but then other circumstances are there.
Not only that weapon of assault, whether it was that I did not.
No, the sketch map shown that where the knife was thrown, my lord. There is no sketch map, my lord, showing the pond, my lord. The place.
That part of evidence is not there, but.
That is not a requirement.
Mm.
The requirement of in a criminal prosecution
My lord,
is that the sketch map of the place of occurrence is always prepared.
my lord.
You can show me an authority. I'm subject to
I'll show,
correction.
my lord, I'll show.
Only the place
That
of
the
occurrence.
that the
yes.
place where the knife was thrown, that may not be a perhaps.
I'll show, my lord, one judgment.
Because
That-
section 173 requires only place of occurrence.
Place of occurrence.
That will be shown by a sketch.
My lord, Justice A.K. Goswami has dealt with that position, my lord.
We'll see that.
Okay.
I'm not aware of that judgment.
On 21st of August.
Because you see, now let us take an example. You perhaps have seen the trial of, or you have heard of the Sudodia murder trial.
Mm.
You have heard it?
Yes.
Heard, read.
Huh?
Read it, but not to so much of
I'll
detail.
tell you. When you go in Burapahar, when you cross towards Jorhat, you go to Burapahar.
Yes.
On the left side, if you go from here, you will find a small board where the Sudodia family was murdered here.
Acha.
There's a small board.
Huh.
What had happened was the one of the brothers murdered the other brother, took the dead body from Purapahar, carried it towards Shillong, that Umiam Lake, and the White Ambassador car where the dead body was kept was sunk in that Umiam Lake
Along with the body.
along with the dead body. The driver was also there. He was also murdered. He was also presumed to have been died. He was also thrown. He survived.
Driver.
Driver survived. He came out, and then villagers came. This car was pulled up, and then the trial took place, and the brother was convicted. So I'm saying with a reference, not with the trial. Trial is not my motto. But what I'm saying is that, assuming that somebody said that in a valley, the car was thrown or the car was dumped at a particular place, and then if there is a requirement that a sketch map is to be prepared of the place where the car was dumped, then maybe we'll have a distance of 5 kilometers that it is dumped between place X and Y. X and Y maybe a distance will 5 kilometers, maybe 1 kilometer, and then to make it have make a map. Can you think of the difficulties which the police will face? Body was somebody threw the body in the Brahmaputra from the bridge. Now to estimate it by a sketch map. Now, if I ask a question to myself, how is the court benefited out of where it was thrown? The dead body was taken to the Brahmaputra bridge, thrown. Now, how is the court concerned with that? I can understand the dead body found in a place, situation is given, and the situation is placed for a reason. You know why? Why? Why is this sketch map prepared in the first place?
What do you mean, identification of the
No. To recreate a situation as to how the dead body is lying, how did that happen? Because somebody will say, I saw him hitting from the left to right, and the injury is on the right to left. So that makes the version disbelievable of the witness. So therefore, the inquest report and the site of the dead body is prepared so that everybody can understand how is the house situated, where is the say yesterday a case came up where somebody saw an incident from the backside of the house. Now, if the house map is placed from the backside, it is highly improbable that somebody would be able to look at the place of occurrence. And so therefore, the court will find which witness can be believed, which cannot be believed. It gives a situation of the house because the court is not there to inspect the place of occurrence. So therefore, the inquest report is there. 173 requires that a place of occurrence be described. We'll see the judgment. I'm not seeing the judgment. I'm not commenting on the correctness of it. If it is authored by Justice Goswami, then yes, he will take a very
Detailed.
what you call very conscious decision.
in that case, my lord, the one dagger was recovered from a place, my lord. That was not shown in this case.
Perhaps it was seized from that area and so perhaps it was seized from the same place of occurrence and it was not shown in the sketch map. It was lying in the. It all depends upon the facts.
Unless you read the judgment,
It all
Place
depends
all those
upon.
documents.
Because
21st then.
24. Yes, item 1.
Please. But I'm here to make a mention, my lord. Very unusual prayer, my lord, with all due respect. This is a bench 3 matter, my lord. And then I'm praying for a listing of this particular matter tomorrow, my lord, because this is regarding the judicial grade 3 examination, which is going to be holding on 11th of this month, my lord. Day after tomorrow.
I'm not the assigned bench. I can't take up.
My lord. as per the roster, my lord was to take up bench 3. My lord is heading. That is the reason why I'm mentioning this.
No, I've been assigned division bench.
The roster which is in my hand, my lord.
No, that will not be there because the roster has changed. It was there on Monday, but suddenly the roster is changed. Now I'm heading the division bench in these criminal matters. Well, that was there on Monday, but now I've been assigned a different bench. I can't.
Then it will be my mistake, my lord. The
No, it may not be your mistake.
roster which is in my hand, that is still 11th, my lord.
No, I understand, but that roster is not being followed. These are these single bench matters which have come are assigned matters because they are either for correction of orders or they are those bail applications which I have rejected earlier. So I am not being interested with any other matter right now. We just move the registry.
My lord, the problem with this particular matter is that this is against the registry.
No, that's
of this
okay.
court, my lord.
No. You see, you may be agreed by even by the orders of the honorable judge. But still you have a right to move the court. Correct. So I think you move the registry because I am unable to consider the request since I am heading a division bench. These matters are incidental because either the bail matters have been refused by me, that's why it has come, or it is for correction of orders. No other matters are assigned to me. Or maybe it is a parted matter that's why it will come.
No obligation.
Item number 3, motion BA.
Your lordship had earlier rejected it, my lord, on 12/6/23, my lord. But here, my lord, the rejection order, your lordship will find, my lord, from, my lord, page 37 onwards, my lord.
This records are available in BA 2401.
Yes, my lord.
So we'll call that. We'll take
Yes,
it up.
my lord. My lord. My ground is that, my lord, although your lordship directed to, my lord, the court below to take up, my lord, day to day, my lord. But the witnesses still remain, only 2 were examined. Till date, my lord, no one turned up. And moreover, another submission is that, my lord, your lordship will see in, my lord, page 38 for a once, my lord, paragraph 4.
Yes.
My lord, he was arrested in another case, my lord.
Yes.
The 302 case, my lord.
Yes.
Subsequently, my lord, in that case also, no one turned up for, my lord, for deposition. So that's why we have been granted bail, my lord. And in that case, my lord, the FSL report, which shows, my lord, the poisoning, my lord, no poison was found, my lord. That's why bail was granted, my lord. So here in the instant case, my lordship may call for the LCR.
No, instead of LCR, it will delay
Yes,
the trial.
LCR.
We call for the records of BA 2401.
Yes.
The witnesses you have annexed here.
Yes, my lord, only 2, my lord.
So we'll take it up along with that.
Right.
When should I fix it?
Registry will perhaps bring it.
No. When do you want? When will you be prepared?
Lordship, any day, because here Lordship is calling for the records of the lower courts.
No.
Oh.
Of the earlier bail application.
Earlier bail application, Lordship.
It has the scanned copy of records, so we don't need, not call it again.
Yeah, any day Lordship will fix it on 16th of August.
Okay.
16th of August.
Mr. Anjit Dutta, counsel for the petitioner, and Mrs. Jahan done a review for the state. Next paper. It appears that the scanned copy of case records is available
In BA.
in the records of BA 2401 of 2022.
My lord, sorry, 1557, page 37.
No.
And that one also, both.
Both. 2401. Thank you.
Oh, okay, as well as BA 1557.
Yes.
Of 2023. First of all, it is submitted that Thereafter, only two witnesses have been examined
Right.
and the deposition of the said witnesses are filed with this application.
Right.
Next, accordingly, along with the said records, list the matter on 16/8/2023.
There's two witness not after this order, prior to the order, my lord. In January, they get the position record. Not after this, after your lordship order. After your lordship order, nothing happened.
No. How many witnesses we examined so far?
Two out of 11, two.
That is there in page 38 also we have recorded.
Yes, my lord. That was recorded in the month of January, my lord.
So it's not recorded. Thereafter, no.
Thereafter.
Don't write that.
I'm obliged.
For bail hearing,
Oh, that case diary, I have not received today. It was, the communication was sent on 3rd of August, but it's not received in our office.
9/8/23.
9/8/23 was the order and our
After
communication.
2/8/23.
2/8. 3/8, we have sent the communication for sending the CD, but. Lordship will
By
give
when you will
us
prepare?
Golaghat.
What is it?
So any, a week's time,
Give us a date.
17th of August.
Instead of that, we make it 16 because 16th we are fixing a
Lordship
bench.
is sitting, Lordship,
16th.
16th of.
Now this is Edeka Council for the petitioner and Mr. Jahan Laner APP. Next, the Laner APP space for some more time to produce the case diary. Next, list on 16/8/2023.
item number 1 for orders.
Yes.
Lordship, my lord, there is my lord typographical mistake, my lord, in the read petition. In my lord, respondent number 3 has been written as my lord, the subdivisional, my lord, the officer has been my lord. Respondent number 3, my lord.
Yes.
The divisional officer, my lord, instead of my lord, the subdivisional, my lord, subdivisional officer. My lord. And my lord, in the order also, my lord, order dated 22/6/2023, my lord. That respondent number 3's name has not been inserted, my lord. Respondent number 3 is written as Vikas Hazarika at page 9, my lord. Annexure A, my lord.
Just. Okay. Mr. N. Sarkar, Laner counsel for the applicant.
Yes, ma'am.
Has referred to the cost title of the connected WPC 3593 of 2023. And it is submitted that the respondent number 3 is wrongly written as the subdivisional inverted commas, the subdivisional inverted commas. And it is submitted that the word engineer has been omitted.
My lord, officer, subdivisional officer,
Subdivisional?
officer.
No, I think it will be SDE. What do you call your this officer? Subdivisional engineer or subdivisional officer?
Officer, officer, my.
Subdivisional officer.
I'm instructed by my senior. We don't have any objection regarding this.
No. I'm not asking what your objection. It is the subdivisional engineer or it is a subdivisional officer? What is the nomenclature?
I don't have no knowledge about.
You call your senior and ask him. Well, I think it will be subdivision engineer. You just call your senior and ask him whether it will be subdivisional officer or it will be subdivision engineer.
Yes, ma'am.
You go out and call him. अच्छा, officer of the engineer, এটা হলো, হ্যাঁ? Officer of engineer. So accordingly, it is prayed that the applicant be permitted to correct the cost title in respect of respondent number 3. So the prayer is allowed. The applicant is permitted to correct the cost title in respect of respondent number 3, which shall be done in the presence of registrar within bracket judicial. And the learned counsel for the petitioner shall provide a typed copy of the cost title to be inserted in the in the connected late petition. Next para. The learned counsel for the petitioner has applicant has also submitted that due to inadvertence the name of respondent number 3 has been left out in the cost title. It is contained in the order dated 22/6/2023, passed in the connected WBC 3593 of 2023. Full stop. The registry shall take a note of cost title of WBC 3593 of 2023, as well as the title, cost title appearing in the certificate copy of order dated 22/6/2023, passed in WBC 3593 of 2023, within bracket. Which is available in this interlocutory application, and shall direct the office to incorporate the respondent number 3 in the certified copy of the order, and rename the and renumber the respondent number 3 and 4 as respondent number 5 and 4 and 5 respectively.
It's engineer.
It should be engineer.
Yes,
So not officer. Again, you'll have to amend it. What do you want? You want to amend it again?
No, my lord.
No,
Engineer, my
okay. So the engineer, huh? Full stop. The learned counsel for the petitioner shall surrender the certificate. This year we will surrender this. Surrender the certificate copy of order dated in 22/6/2023 in WBC 3593 or 23. Center cut कोई भी लगे. Huh? Copying section to the copying section. After the cost title in respect of respondent number 3 is corrected. Next, this order shall be read together with order dated 22/6/2023, passed in connected WBC 3593 of 2023. Oh, your name I did not record.
W. Ahmed.
W. Ahmed for the opposite party. APDCL. Opposite parties number 1, 2, and 3. APDCL. Okay. 2. Yes. Yes.
My lord, by way of this interlocutory
This
application.
PWD, I think you'll have to call someone. Who was there, Mr.
Though appeared on the earlier.
Gogoi or Mr. Nayak? Just give them a call.
My lord.
SCPWD.
I'm sorry, my lord, in the 100-day, my lord, some typographical mistakes were there, my lord, and wrong annexures were there, my lord.
Yes.
My lord, Anand Council, who was along with me, my colleagues, my lord, two repetitions were there, my lord. One wrong
Yes,
annexure.
I know. It took us a lot of
Yes, my lord.
mistakes. As we
Otherwise,
got a
my-
problem.
Hmm.
The court master, my secretary, everybody had to sit down and then find out what has happened.
Yes, my lord.
Huh.
I'm sorry,
So
my
now
lord.
you have corrected it.
Yes, ma'am. Already corrected.
Huh.
Now, my lord, only to your lordship order, my lord, 24/7/23 order in the writ petition. In the last but above paragraph, only to add, my lord, to dispose the representation.
Okay. But Mr.
Is there?
H. Das, then it comes for the applicant. Mr. K. Gogay, additional senior government advocate appearing for the respondent number 3 and 4. You're there
Yes, madam.
in,
PWD for PWD.
no, this is this is another matter.
Sorry.
AFDC is Mr. P. Sharma. Pranjal Sharma. 1 and 2 is Pranjal Sharma, P. Sharma, SARMAH. Mr. K. Gogay, government advocate appearing for respondent 3 and 4. Next madam. By filing this interlocutory application, the applicant, who is the petitioner in connected WPC 4049 of 2023, has prayed for correction of the order passed interlocutory order passed on 24/7/2023. So it is submitted that this court, while dictating the order, had directed that, inverted commas, pendency of the writ petition shall not be a bar for the respondent authorities, i.e. the managing director of Assam Fishery Development Corporation, to
dispose of the representation, my lord.
oh no, sorry, we're not shall be a bar for the respondent number 2. Respondent authorities, the respondent number 2, i.e. managing director Assam Fishery Development Corporation, to dispose of the representation dated 10/5/2023. Full stop. Inverted comma close, full stop. So it is submitted that that in para 5 of this said order, certain words were dropped, and the para 5 of the order reads as follows. Page 8. Pencil mark. Next para. The contention of the learned counsel for the petitioner appears to be correct, as para 5 of the order is typed in. The order dated 24/7/2023 is does not carry a meaning. So accordingly, the typographical error in the order stands in the order dated 24/7/2023 stands corrected. The paragraph 5 of the said order dated 24/7/2023 shall now read as follows. Pendency of the repatriation shall not be barred for the respondent number 2, i.e. Managing Director of Assam Fishery Development Corporation, to dispose of representation dated 10/5/2023. Next, this order shall be read together with order dated 24/7/2023, passed in the connected list. WBC 4051 of 2023. Second order, same mistake.
Same, man. Case number will be, repetition number will be.
Second order, the lead petition number is 4051 of 2023. Same mistake, no?
Represent data also same.
Okay.
Right.
You're sure because I have not opened the second file.
Yes, certain fisheries name different.
No, whatever we have
Yes,
seen
ma'am.
it this time.
Yes.
Yes, ma'am. Yes.
My lord, if the lordship recollects, this was the case where the apprehension, my lord, espoused before your lordships was regarding, my lord, damage to the building of the petitioner, my lord, which was not a part of the acquisition proceedings. And while, my lord, hearing on the petition, my lord, the statement had been made, my lord, that there was no, my lord, intention to damage the building, my lord. Now, my lord, what happened on that moment, my lord, a photograph was shown, which showed that only the awning, my lord, in the building, that would be covered by the area, my lord, which is sought to be acquired, my lord. Now, my lord, there are some photographs which shows, my lord, that, my lord, my lord, if your lordship kindly turns to page number 20, my lord.
20.
20. It's a photograph, my lord. The second photograph. Where your lordships below, my lord, lordships will see that the number, my lord, 3.55 is written, my lord.
Yes.
That 3.55, my lord, if your lordship turns to the other pages, it will come, my lord, just to, my lord, 1 foot of the building, my lord. So that is the area till which, my lord, they intend to acquire, my lord. It will just come to 1 foot. Now, my lord, if your lordship turns to the last page, page number 23, my lord.
Yes.
23, this is the manner in which, my lord, the drain is being constructed, my lord, which is now about to reach the petitioner's house, my lord. There your lordship will see the inner walls of the drain, my lord, and the external excavation done, my lord. The external excavation, my lord, from the inner walls is around 1 or more than 1 foot apart, my lord. My lord, if in this manner, my lord, if the excavation goes, my lord, then, my lord, my building will fall. Because what will happen is, my lord, the soil underneath my building will be taken away, my lord, and the building will not be able to stand. So, my lord, my prayer before lordship is to modify, because the direction contained in the earlier, my lord, order, my lord, ultimately my lord, that paragraph 7, that is the operative part of the order, my lord.
You get instructions on this, we'll take it up tomorrow.
Yes, ma'am. Because lordship, it can be disposed of by saying that they will employ whatever, my lord, techniques is necessary to see that, my lord, the building is that part in the operative part, if that is given, my lord,
No,
that
he has
will serve
understood
my
that.
purpose, my lord.
Please ask him that your concerned engineer the same question, whether the any likelihood of the building falling down.
Yes.
Because he says that if the excavation takes place, then the foundation will become weak,
My lord.
and it may fall down. That is your contention.
Yes, my lord.
Yes, lordship.
Because from this margin line of 3.55 meters, my lord, there is only around 1 foot left. So as per the earlier photograph.
No, you see Mr. Chaudhary,
My lord.
Although I have no experience with the construction,
My lord.
but what I understand is that the foundation of the building,
My lord.
is made on that, the pillars are coming up.
My lord,
So even if the road comes to say
my lord,
zero centimeter from your
My lord.
pillar,
my lord,
unless they touch your foundation,
my lord,
your building is otherwise safe.
my lord.
That is the impression I have.
What happens?
I may
my
be
lord?
wrong, but
There was, my lord, one mall here, if your lordship has noticed in the GS road, one Rudraksh, that was near the earlier Big Bazaar, my lord. While construction of that mall, my lord, there was a complaint made by Hindi school, which was on the backside of the school, saying that due to the construction works of that building, my lord, the walls of the school got shattered. And a petition was filed here, and ultimately, my lord, it was stayed, my lord. Thereafter, my lord, the people, my lord, who had been constructing the Rudraksh mall, my lord, they had come up with the engineers, my lord. They say there is a way now, my lord. What they do is, suppose, my lord, my house, this is the end of my house, my lord. They put up a steel, my lord, wall just here, my lord, so that whatever vibration takes place on the other side, this side, my lord, at least the foundation or the subsoil beneath my house is not affected. By that way, they can go on with their works, my lord.
retaining wall, you are saying retaining wall.
It's not a retaining wall. They put that steel wall, my lord, during the process of the excavation. When the work is done, then they remove it, my lord. So when they remove that steel wall, ultimately, in the meanwhile, my lord, that cementing process all goes on, my lord. And then, my lord, that subsoil does not get eroded, my lord. When the subsoil doesn't get eroded, then, my lord, that building is safe. Here, what happens, my lord,
You take
today.
2 minutes time and explain it to Mr. Chaudhary.
Lordship, I have
Yes,
understood, Lordship.
So, my lord, my prayer before lordship is that for direction, my lord, that they will employ whatever modern techniques are
Let him take
available.
let him take the instructions. Let him, we'll take it up tomorrow.
My lord,
Let him take instructions.
my lord,
This is something which I don't understand.
my lord.
The implication of the order I wouldn't understand, so therefore. We'll have the capability.
Okay.
Uh, Just listen to him because this is something I won't understand. Correct.
Because ultimately that matter, it went up to the Supreme Court, my lord, because lordships were not vacating that order here. Then I appeared there, my lord. Ultimately, my lord, it was said that, my lord, that construction will come up with an undertaking that if anything happens to the school or us, we will repair it. But ultimately, it had been done in a manner by employing that technique. So there was no effect on the school at all, my lord.
Okay. Mr. G. Chaudhary, counsel for the applicant, who submits that if who prays for modification of para 7 of the order,
My lord, to add, my lord, those lines only.
so as to ensure that the existing structure of the petitioner, the applicant's building is safe. Mr. V. Chaudhary, the current standing counsel for PWD, is given time to interact with the concerned officials. On the nature of prayer made by the applicant. Next list tomorrow. Give him an extra copy because otherwise.
In the SD matter, my lord, in that SD matter, whether the name will be SD or SDE, in the earlier matter, my lord, the lordship opined whether it will be SD or SDE. Ultimately, my lord, the petitioner said that it would be SDO, but it was clarified by your lordships that it will be SDE. So that runs converse to that section 57 of the my lord Evidence Act.
No, that is not law.
Even then, my
That
lord,
is fact.
my lord, whatever falls from your lordship mouth is law, my lord. So, my
No,
lord,
no. That is a fact. Because that will be law only after I have the power to invoke 142.
my lord.
No, you see, that SDO, SD,
My lord.
I know because of the fact that earlier when I had to do drafting,
My lord, my lord.
you have to be very sure what to,
Yes, whom to plead.
want to implement.
My lord.
So therefore, that is why I remember, because
My lord.
earlier it was SDO.
Yes, my lord. Now the
Then
nomenclature.
now the offices of the APDCL
My lord,
are manned by engineers.
my lord.
And therefore now they have nomenclatured
As
it
engineer.
SD because all the officers who are now manning the post of ASB subdivisional officers,
My lord.
they are engineers and therefore it is SDE.
SDE.
That is something which I know because at that point of time we had to do the drafting and therefore. Drafting for a civil court is too tedious.
Yes, lord.
Because what had happened was in the earlier case also, application for for correction of the order came.
My lord.
I did not see it and I allowed the application because it was correction of a name,
My lord.
Mr. H. Das. that
My
matter.